Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey guys, I wanted to give you guys a little bit of an update on the Wright versus Malone case. This is the case that James has filed in civil court requesting damages for the injuries that he sustained on the, what was that, Tamar Braxton tour, I would say. So let's hop right on into it. So last that we spoke, the last thing that was filed on this case was the declaration of James Wright to in support of the default judgment that he's trying to enter. We went over all of his medical record bills because he didn't have any medical records to support any of the bills, as far as the therapist and the dental records. But then there was also a bill for the process server, so on and so forth. There was no attorney fees bill or anything of that nature. And then also, Chrisean's attorney filed a case management statement, pretty much letting the court know where they are in the litigation process. And that pretty much was stating that what we have read, that they have requested certain things from the plaintiff, but the plaintiff is refusing to provide either the medical records to support the bills. And then in addition to that, uh, they are not. He's not completing any of the authorization, so that way Krishan's attorney can actually obtain the records for themselves. Now, as I stated, on the plaintiff side, we normally don't even have our clients complete the authorization. So that is standard. But we do, and I actually put together these discovery requests and send them over to opposing counsel. So if they're requesting medical records and medical bills, that is what I put together and I sent to opposing counsel. Why James Wright attorney is not doing this, I have no clue. There could be only two options. One, there are no medical records to support, or there are records to support, but it's not really in the case where it will help James out in the long run. Honestly, I have no clue as to what James Wright attorney is doing. I am really confused. And as a plaintiff's personal injury paralegal, I have handled I am handling PI cases in California. So I don't know if it's because this attorney is fairly new in this arena. I have no clue. As I stated time and time again, there are different areas of law. We went to his profile and we looked at his website to kind of see, where he was, and it did mention that he took on personal injury as a new practice area. But I don't know if that was last year, this year, but from what I am seeing, he is not helping James' case at all. uh, at all. So the most recent filings is on the 14th. They submitted another request for entry of default judgment, and then also an amended declaration in support of the default judgment. All right, so let's go into and see exactly what that entry is. So here is the application for a request. It's not a motion, it's not a notice, okay? This is a request to enter a default judgment. So normally what happens is the judge will review and see if they have supporting evidence, meaning medical records to support the medical bills and whatever other damages that he is seeking. So, do you have this? But also, they're going to take into account, when did you file this? The last, let me see, minutes that I read, and if you have not, if you don't understand what the minutes are, please go watch the last live that I did explaining all of this. But the judge clearly stated that the request for default judgment, for the entry of default judgment, was discharged, and he did order for Krishan's attorney to file a motion to strike. So I am assuming that because they entered a new request for a default judgment, that Krishan's attorney is now going to file a motion to strike. So I am going to keep you guys updated on this. So this is nothing new as far as everything. So it does just, it says to the clerk when they filed the complaint, who the complaint was filed by, Now, this D is very, very important because it says, I request a court judgment under Code of Civil Procedure sections 585B and C and 989 against defendant Chrisean Malone. Not to understand, because I did mention prior that you have to submit a default judgment within so many days of the respondent or the defendant not answering. So I want to kind of school you guys on what those procedures are. So first and foremost, if we see here, and hopefully y'all can see this. So the request for fault, this is what it reads. This is the most updated California rules of the court. Anytime I am working on any case, it doesn't matter the jurisdiction, it doesn't matter the county. I always go to the state local rules as well as that specific court local rules because you want to make sure that you do things right the first time, and you have to abide by whatever the rules that specific court or that county or that state requires. So here for the request of I'm sorry, request for entry of default, it reads, if a responsive pleading is not served within the time limit specified in this rule and no extension of time has been granted, the plaintiff must file a request for entry of default within 10 days after the time of service has elapsed, meaning that Chrisean was supposed to file an answer within the specific time period. So the summons said 30 days. So she did not respond in 30 days. Therefore, within that 10 days after the expiration of the 30 days, James Wright, his attorney, was supposed to file a request for entry of default judgment. All right. So it says, then the court may issue an order to show cause why sanctions should not be imposed if the plaintiff fails to timely file the request for the entry of default. That's the reason why they were having the if you see the case management conference or status hearing, it'll show order to show cause, and they will, ask the either party like why you did not file this in a specific period of time. So the last request for an entry of default was discharged. So then he filed another one on the 14th. I don't understand why, because it's still outside of the time limit, and Chrisean did answer. All right. Now, default judgment. So, when a default is entered, the party who requested the entry of default must obtain a default judgment against the defaulting party within 45 days. 45 days after default was entered, unless the court has granted an extension. The first entry of default was filed literally in September. In September. So she was served in May. The 30 days expired in June. He did not file his first request for default judgment until September. So those 45 days are up. All right. Then it goes on to say the court may issue an order to show cause why sanctions should not be imposed if the party fails to obtain entry of judgment against a defaulting party or to request an extension of time to apply for a default judgment within that time. So he has missed out the 10 days and he has missed out on the 45 days. Honestly, I don't know the angle that the plaintiff's attorney is going. I am lost at this point. And I'm lost because I handle these type of cases and I know the process. I just don't know what angle his attorney is going. It's not looking good. Now, I do want to go back to uh he's requesting a court judgment under Code of Civil Procedure section 585, 585 B and C, and 989. So what are those procedures? So let me go and do this right quick. And I, because if we click on that, the actual code is going to be so confusing. All right, so 585B. Now, this is just talking about a landlord, but it still applies. So they are able to request a default money judgment against a other party, okay, under the California Civil Rules of Procedure. Okay. And it says a party can request a court judgment under 989. So in all, this is what it is saying. That particular rule is stating that a defendant can enter into a default if they fail to answer a complaint. The principal amount demanded, the interest allowed by law, cost of the defendant, and attorney fees. So these are all the damages that the plaintiff is able to collect on. But a default cannot be entered if the defendant has responded with an answer. All right. So yes, even though Chrisean responded late, she still responded. Okay. Otherwise, the court would have already granted this defaultment for plaintiff. But at the same time, if Chrisean didn't answer, or if the judge did not, grant the default judgment, James is still, the burden of proof is still on James to prove that those medical bills that he endured and all the expenses and so on and so forth was related to the injuries. So that 138K that he's requesting, as I stated before, he has to prove he has to prove that. Okay, the judge is not just going to say, "Oh, all right, you're requesting 138,000 and pay that." It does not work that way at all. Okay? Um Now I know that when Chrisean's attorney filed the case management, um, what was that statement, she did request that they settle. So it not settle, but they have a mediation. Okay, and let me go with that. So a mediation can happen at any time, but a smart attorney will not go to mediation without getting all of the documentation that's needed to look over the case and review the case, because nobody's going to sit there and negotiate a settlement and you don't know exactly how much the damages are, and you don't know if any of the bills that they're adding to the suit is actually related to the injuries. Okay. All right, so that is that first part. Now I want to take you guys to the declaration. Now, this is an amended declaration that his attorney submitted. For it says amended declaration pursuant. Okay, we got all that. Nothing has changed as far as the facts. The only thing that has changed is the total amount that is now being requested. So administrative fees is no longer here. Okay. The damages have increased from 71K to 77K. Pain and suffering, 50,000. Service of process, $2,106. And attorney fees, 15,000. That's it. Now it says outlined below are the exhibits to prove up the judgment and the total amount. So remember, the plaintiff always has the burden of proof. But where are the exhibits? No exhibits were attached. So I don't know if the attorney didn't do what they were supposed to do, or the paralegal for that attorney didn't do what they supposed to do. But yeah, so now you amended a declaration and you did not provide any type of documentation to prove that. It's not making sense to me. All right. So that was the declaration to support this. Now, you said the judgment to be entered is $145,032.70, yet you did not provide any type of medical records or bills to support um your judgment that you're requesting. All right. Furthermore, that I found was very weird is that, and I only showed this because she no longer lives there, but yet you did not mail this to the defendant's attorney of record. I hope y'all see this. That's why I was like, I don't know if the attorney knows what he's doing, because it clearly says mail first class postage prepaid in a sealed envelope addressed to each defendant's attorney of record, or if none, to each defendant's last known address. I don't know if this attorney knows that Chrisean has an attorney. And yes, the attorney is still on the case. Miss Monica is still on the case. So I want y'all to see that. Monica's still on the case. However, he sent this to an address that Chrisean is no longer at. Then we have the memorandum of fees. All right, so here's the process server fees. All right, so the process server fees has gone down. Because remember, well, I don't, yeah. I don't know about that. 1656, and then the clerk filing fees 435. So we have a total of 21.6. All right. So this is what disturbs me. So you sent a copy of the declaration to an address that Chrisean is no longer to. However, she does have an attorney. That's number one. Number two, you amend a declaration, but yet you still did not prove up any of the damages by attaching the medical records, the dentist records, and the therapist records. You stated that you went to a therapist for 3 months, right? You submitted a bill in the last declaration, but no medical records. You showed the bill for dental records, but not the dental records. You have a bill, but no records. As a plaintiff, personal injury paralegal, this is not going good on James's case. Honestly, James, if you listening, I would find me a new attorney to work on my case, because this is not the way that it is supposed to going. I really don't know what the angle is going here. The documents have not been provided to, Chrisean's attorney. The request for entry of default judgment has been entered way, way past the expiration date. It's all over the place, and it's really giving that the attorney does not know what he's doing. So please, if you are not a supporter, don't come at me and be like, well, you're just no, this is from a paralegal's point of view. I handle plaintiff personal injury. The way that this case is being handled is incorrect. It can jeopardize uh Mr. Wright's civil case. It really can. Everything that has been done incorrectly. Always remember, and I'm going to keep saying this, the plaintiff or the petitioner has the burden of proof. In an injury case, you have to prove up your damages. You have to show documentation. You cannot just submit bills, because those bills can be for anything. Y'all tell me what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.